I'm Scott Loughlin. This is the Data Chronicles, and here are your data points. Today, we're going to be discussing the second half of the proposed rules that were issued in California under the CCPA. You may remember from a past episode that we discussed what proposed rules could look like for doing privacy assessments. And we had a really deep and thoughtful conversation about what those proposed rules could look like and what that means for privacy practitioners going forward. Today, we're going to be talking about the other set of proposed rules that dropped. And those relate to cybersecurity, in particular, the need to conduct cybersecurity assessments and what that would mean for everybody who is in the cyberspace, whether that be working with privacy professionals or that be working with the cybersecurity and data professionals within your organization. To discuss those draft regulations, I have two of my colleagues joining me, Dan Ongaro, who's a member of our Minneapolis office, and Alaa Salaheldin from our Washington, D.C. office. Alaa, maybe I can start with you, and if you can just maybe set the stage. What were these draft regulations that were proposed, and why are we seeing those being released at this time?
Yeah, absolutely. So as listeners to the podcast may know, the California Consumer Privacy Act was the first comprehensive state privacy law enacted in the United States. When California voters chose to vote in the CPRA to amend the CCPA, the new CPRA amendment created this broad rulemaking authority for the California Privacy Protection Agency to issue various regulations, including specifically defining the scope of new cybersecurity audit requirements for processing activities that present significant harm to consumer privacy and security.
So it sounds like this set of statutes, the CCPA, the CPRA, kind of coming together, gave broad rulemaking authority to the state of California regulators to issue more specific set of requirements that would come under those laws. Is that what we saw with these proposed regs, or we're not even at the stage yet of actually having proposed regulations?
Yeah, so absolutely. So right now, the CPPA is currently in the formal rulemaking phase in terms of the cybersecurity audit requirements, similar to the privacy risk assessment requirements that were recently discussed on a previous podcast. In August, the CPPA issued a discussion draft of proposed rules governing the scope of cybersecurity audit requirements. This draft is not part of formal rulemaking, but instead effectively acts only as a roadmap to facilitate the board discussion and also discussion by the general public around what the cybersecurity audit requirements may look like. Notably, the cybersecurity audit related requirements do not exist under any other comprehensive state privacy law, but it does appear that the CCPA is attempting to harmonize with other existing sectoral laws to confirm the scope of applicability for cybersecurity audits under its comprehensive state privacy law.
So let's just then jump right into this. Right? What does it mean to conduct a cybersecurity audit, and when would a cybersecurity audit be required under these draft proposed regulations?
Certainly. So the CPPA is proposing cybersecurity audits for businesses depending on a number of potential applicability thresholds. They effectively appear to be defining the scope of activities that present significant risk to consumers based on entity size, revenues, and so forth, as opposed to clear processing activities that present significant risk to consumers. This appears to be distinct from the privacy risk assessment requirements issued by the CPPA, also just before its most recent meeting. So what the CPPA appears to be looking at is a number of different potential revenue thresholds that would trigger a cybersecurity audit requirement for a business. While listeners may know that the CCPA applies to covered businesses that conduct business in California and have revenues in excess of $25 million, among additional applicability thresholds, the CPPA is looking to further narrow the scope of entities that may be required to conduct cybersecurity audits under the regulations. And currently, it appears that they're looking at three separate options here. The first being thresholds around the processing of information, number of individuals whose personal information is processed in a year, also number of individuals whose sensitive personal information is processed, and are alternatively in that specific prong, the number of individuals under the age of 16 for whom the business processes personal information. These specific thresholds, however, are not yet determined. Separately, the CPPA is considering applying the cybersecurity audit requirements to businesses with gross revenues in excess of a certain threshold. Again, it's not yet clear what that number will end up falling at, but presumably over 25 million, given CCPA will only apply to entities at least in one of its applicability prongs that have annual revenues in excess of 25 million. And as a last option, CPPA appears to be looking at the number of employees that a certain entity has in order to determine whether cybersecurity audit requirements would apply.
So, Alaa, it's almost like the CPPA is coming up with a strategy to develop a subset of entities who are subject to the CPRA. And for that subset, they are looking to identify the largest actors in the state of California, whether that be by revenue, by employees, or the numbers of individuals whose records are being processed. And for that group, the proposal would mean that they need to conduct a cybersecurity audit.
Yes, absolutely, Scott. So the CPPA in its most recent board meeting appears to have stated that their goal in coming up with these specific requirements and proposals is to weigh the cost to businesses against the benefit to consumers caused by these cybersecurity audits. In general, it appears that the CPPA had lengthy discussions around mitigating the burden of cybersecurity audits to smaller businesses.
Interesting. And so maybe, Dan, I'm interested in your perspective on this, because if I hear the need to conduct a cybersecurity audit, part of that is going to be based on the riskiness of the activities that you're engaged in, including the different types of technologies that you are leveraging to engage in the data processing and what types of unique cybersecurity considerations that those create. What I hear Alaa saying is that, well, actually, that is not the methodology that we are using for this. Instead, we're actually just looking at almost arbitrary thresholds, saying if you have X number of employees, you need to conduct these assessments. Or if you have revenue over this particular amount, then that's going to result in a need to do a cybersecurity assessment. And it's almost using those thresholds as a proxy for saying you must be doing something that's risky from a cybersecurity perspective, and thus you need to audit it.
Yeah, Scott, I think that's a fair point, that the CPPA appeared to really want to set a bright line. And you actually see this later on, where when they talk about the scope of the audit, it starts out very much as giving auditor discretion, making it sound like you would have the ability to really focus the audit on the business specifically and its needs, its technological functions, the type of data. But as you proceed on in the proposal, it gets narrower and it is quite prescriptive. There are actually 18 areas specifically required. Now, CPPA does give you the option as an auditor to say what might not be in scope or it might be inapplicable, but you're very spot on where they are quite drawing a bright line and saying these are minimums that regardless you would expect your business to have.
So talk to me more about that point that Alaa was just mentioning, right? Because she was describing the CPPA as being very focused on trying to minimize the impact that this would have on small businesses and trying to compare that against the benefit that would be provided to consumers. How do you see that impact playing out for an organization who is already working toward trying to meet a variety of cybersecurity related standards, which, as you know, can come from a variety of different sources and are not always consistent or coordinated among them.
Yeah, the impact in many ways will depend on what the organization currently is doing and what sort of infrastructure it has in place. So one thing this proposal offers is that you can leverage your existing audit. Now, that being said, you're required to demonstrate how that existing audit would necessarily give you coverage over what the proposal has currently laid out that's specifically required. And there are some companies that likely this won't be a problem. There are others, including companies that maybe at this point just have a SOC 2 assessment, that there will be a fair amount of additional audit procedures that would be required for them to comply with the current proposal.
And I want to kind of get into what is being proposed in terms of the substance in a moment, Dan. But before we lose sight of the scoping question, Alaa, maybe one last question for you on scope is, does this only apply to California businesses? Or would these obligations extend to the service providers and contractors and third parties, kind of all of those other terms that are included within the CCPA, where now those organizations would potentially have cybersecurity audit obligations under these draft rules?
Yeah, absolutely. So in these draft proposed rules, the CPPA appears to extend some of the service provider and contractor oversight obligations that currently exist on businesses to review of cybersecurity compliance measures that those service providers and contractors have put in place. In addition, it looks like these rules specifically require service providers and contractors to cooperate with the business in providing all information requested by the business or its auditor around that is deemed necessary to comply with the cybersecurity audit requirements.
And one thing to add on there that I think is important is when we do get into some of the specific scope, you as a business aren't able to necessarily just delegate everything to a service provider and think that you can wash your hands of this. One of the specific requirements current proposal looks at is what sort of third-party risk management you're doing. As a controller, are you conducting diligence up front of service providers? Are you making sure that they comply? And is there periodic monitoring for that compliance?
Yeah, I mean, that's fascinating because it kind of puts the pressure on a point that I think a lot of our listeners and those in the community would identify already as a pain point in contractual negotiations with vendors. It is often the case that vendors are reticent to share lots of cybersecurity oriented information with their customers because some of that information could be weaponized, right? Because some of it could be used to actually perpetuate cybersecurity threats against that company. And so there's this balance between providing information at the level needed to allow your customers to gain an understanding of how you are managing cybersecurity related obligations, while at the same time not allowing that provision of information to actually result in an increased threat to that organization, given that you are now providing information that could be used against you. This audit mechanism, then the way that you were just describing that, seems like then that just continues to perpetuate this dynamic where now organizations who are subject to these cybersecurity audits need to require their processors to make available information that they have, which would then be factored into how they conduct the audit, how the business originally conducts the audit. It's going to get kind of very confusing and end up resulting in a lot of conversations between business partners.
Yeah, certainly. I mean, it is an incredibly broad scope where it appears that a service provider or contractor would have to give all information that the business and its auditor deems necessary for compliance with the cybersecurity audit requirements. So it is incredibly burdensome and will likely create additional back and forth in the contract negotiation process between businesses and their service provider entities.
Dan, maybe we can jump right into what we think these assessments and these audits would actually look like. So first is, you made the point a moment ago that says that there is, at least under these draft regs, that there is accommodation or a proposed accommodation that you may be able to leverage what you already are doing to satisfy these obligations, which I think will be music to many of our clients' ears so that they don't continue to have to do another audit and another audit. But is it the case that organizations always need to leverage a third party to conduct these audits, or is there an option to do a self-assessment?
Scott, in theory, that absolutely can happen. They do currently contemplate an internal audit function. However, in practice, that would be very unlikely from what we've seen the way governance is normally set up. What the proposal includes is that as a condition of using your internal audit function, they would have to report up to the board of directors or the highest executive in the company. And there's even requirements around who's setting the internal auditor's compensation so that you really have a level of independence that, again, most companies do not necessarily set up for their internal audit function. And this would be a pretty big change just to comply with this requirement.
So Dan, if I'm hearing what you're saying correctly, either we have to do things differently than what we do today, or we have to note that we have to engage an external third-party assessor to be able to do this review to then meet these California standards.
That's exactly correct, Scott. You would have to engage someone separately, most likely than your internal auditor. Now, as mentioned, we can leverage an existing assessment, which if you already do have a third party engaged, you could potentially use. Once again, there is some difficulty in practice of doing that, the way the proposal is currently worded. They have rather strict requirements of independence that go beyond what would normally be considered independent, such that, even if you're involved in consulting, such that you're maybe not implementing a control, but you're just giving some sort of feedback. Right now, the language would be such that you would not necessarily be independent. This would complicate matters for when you think of a number of companies, or maybe they hire a consultant and the consultant comes in and gives recommendations and maybe helps with some of the initial aspects of setup. At least in the current language, it appears that those third parties would not meet the independence requirement. So you would have to either change your scope that you use those existing third parties for, or bring in yet another third party.
And if I may add very quickly, it does appear that the way these are framed is really around the business that's being audited cannot influence either an internal or external auditor. So as Dan was mentioning, it is incredibly important to figure out who is best positioned to conduct these assessments on behalf of the business.
That's a really good point. And maybe it kind of leads me into my next question, Dan, is, as you know, in a prior life, you were doing audits and you were doing these types of assessments. And it's all well and fine to say that you are going to have an independent auditor to be able to conduct a review. The first question is going to be, well, what are they reviewing? And then the second question is going to be, what are they reviewing against? In other words, if we are saying, can any assessor go and say this company and says, well, they have reasonable security based on their review? Probably not likely, right? You have to have some sort of methodology that you're using to conduct an audit, whether that be ISO or NIST or any of the other frameworks that are out there. Do we know what the assessors need to do as part of these audits, and including what they would need to assess?
Scott, that's a great question. And the short answer is yes and no. The CPPA does lay out certain areas of focus. I know I've referenced them a few times. There's 18 of them. I'm not going to go through each. But that said, some of these are very broad areas. So you mentioned NIST and you mentioned ISO, and there may be 10 plus steps under there that each one of those that may apply. So you as the auditor are going to have to determine, based on the business, and what you think is the intention of the regulation for your framework. And so this gets into the point I was bringing up earlier, that a lot of these are more granular than maybe what we see under SOC 2, where you're allowed to somewhat choose your own adventure and say how you meet certain controls. This is going to be, in all likelihood, closer to a NIST cybersecurity framework, 800-171 or 853 for certain groups that are more likely in government contracting, who have more robust requirements around compliance. And good news for folks that do ISO is, because of the new release of ISO 27000 series that's coming out, there is some additional coverage here that maps to that. So you would potentially have greater ability to leverage your existing assessment. So without further ado, there was just a few of those 18 areas of focus I want to talk a little bit more about, because they're either a newer and hot topic, or because there may be something that isn't going to be surprising, but it's been given short shrift in practice. So the first item that I want to discuss was that specifically named in the proposal is zero trust architecture. So this is a great buzzword and certainly an important concept in security, because all of us on the call have seen what happens when someone gets initial access and able to move laterally. Zero trust architecture should mitigate the effects or risks of lateral movement from an intruder. But as you mentioned, Scott, me as an auditor, if I was still in that life, I can point to certain controls that affect that. But in many ways, I'm left scratching my head how I'm going to test that, because it's not something that necessarily has the greatest criteria. Another item that's a bit of a hot topic, or maybe more unorthodox for many of our clients, that I was surprised to see the proposal explicitly name out, is a bug bounty and ethical hacking program. Now, this is something that a lot of large tech companies had historically put in place because it made sense, just because they were purely software development and they wanted input, and it was much cheaper to pay a bounty up front than have to fix things on the back. It's not something that we've seen the wide adoption for certain other entities. So if there's going to be an expectation from the CPPA that these processes exist, that's going to be quite a change for some entities.
If I'm kind of extrapolating what you're describing, and this is not unusual for these types of proposals, but this is a set of rules that are designed to say these are what needs to be included within a cybersecurity audit. But implicit in the idea that they're going to audit means that they have something to audit against. And so as a result, they're actually imposing potential new substantive requirements, like to have conducted or have a third-party bug bounty program, or to have a zero trust architecture, things that are good practices, but not something that is required as a matter of law, but now they are required from a backdoor perspective.
Scott, that's exactly right. That it would be something that would essentially become a requirement unless you were able to articulate a valid reason why it doesn't apply to your entity. And one other really important piece you mentioned there, which again is something that I see now and saw in my past life in practice, is having something to audit against. So it's oftentimes that companies may have processes in place and everyone just knows to do them. People communicate. This is something that is done. One thing the draft regulations require is that auditors are not allowed to rely primarily on interviews or management's attestations. So this means a lot more paper trail. Earlier, I mentioned federal contractors. Other than folks who are currently federal contractors, or maybe some folks in the healthcare space, this is going to be a lot more formally documenting so that you can not just say what you did, but also show that you have sat down and walked through step by step exactly what you say you do.
Yeah, consistent theme, I think, that came across in the prior episode around the privacy assessments. The need an expectation around creating documentation is growing significantly. And I think these two draft regulations really demonstrate that. Alaa, another question for you here is, so suppose we do a cybersecurity audit and we do this assessment, what then, right? What happens to that audit? Is that then just filed into a drawer, or is that something that has a wider use or wider ramifications?
It absolutely does have a wider ramification in this regard. Even going on the retention period sort of piece, an entity is required to maintain the results of its cybersecurity audit for at least 5 years after completion. And even before then, there's a requirement that the cybersecurity audit be reported to the business's board of directors or governing body, and that the board of directors reviews it and has a member sign and certify that there has been no influence on the auditor who has conducted the specific audit on behalf of the business.
All right. Well, I mean, that raises a whole other set of issues, which we've been dealing with in the past, including maybe Dan under NYDFS around what an executive officer would need to attest to as part of the DFS process. If I heard Alaa describing this correctly, this is actually a member of the board who needs to sign the cybersecurity audit, which would mean that the board would have an enhanced set of obligations in order for them to get comfortable making that certification.
Absolutely, Scott. It's a very unorthodox approach. It's one that raises a lot of questions in my mind, and we've seen NYDFS have to come out with subsequent guidance and amendments to address some of the thorny issues that come up with this. There's some threshold questions that are still outstanding that are covered in the proposal on this. Is, first of all, who has to report to the board? Is this your auditor that's suddenly coming in and doing this? Is this your CISO? It refers to the board of directors. Does that mean it needs to be the full board? Is this maybe your audit and risk committee? Is it the chairperson of that committee? How does that work when you have subsidiaries? And if you don't have a board, you can use the highest ranking official. But again, to your point, Scott, having a member of the board sign off on compliance is just very irregular from a governance perspective.
And Dan, and it's really interesting, and Alaa, I'm interested in your perspectives on this too, because I think what Dan's describing, it requires that there be a level of expertise on cyber matters that sits at the board level, maybe similar to what we saw the SEC propose with its proposed rules. And one of the practical challenges with that is, are there enough board members who have that expertise to sign a document like this, or to be able to play the role that the SEC asked for the cyber board person to play?
Certainly, Scott. In my opinion, it seems there are not enough board members with specific cybersecurity expertise. But given this very explicit oversight requirement, it will become increasingly important for entities to ensure that they have appropriate oversight over these cybersecurity functions, including by board members, particularly given the certification requirements that exist here.
Yeah, so really interested to see where this develops. Fortunately, right, this is only in a draft level. We haven't even gotten to proposed rulemaking, and so there will be opportunities for the CPPA to make adjustments, but also sounds like it's really the time for constituencies and future organizations that are going to be regulated by these rules to work with the state of California to come up with something that is protective from a cybersecurity perspective, but also is practical and allows organizations to operate effectively. In the few minutes we have left, Dan, I'm really interested in hearing your overall take on this. Maybe to highlight that, I'd ask you to maybe switch perspectives, take off your hat as being a cybersecurity lawyer at a law firm and working at its outside counsel. And for a moment, just pretend that you're a cyber counsel with inside of a large tech company, and you are working with those organizations to manage cybersecurity legal risks. You read a rule, a proposed rule, or a draft set of rules that look like this. What steps would you take in response to try to prepare your organizations for what eventually will become a binding set of rules and regulations in the state of California? Alaa, maybe you can go first.
Yeah, absolutely. So I think as an initial step, I would look at whether there is room and environment for my organization to provide comments to the CPPA once formal Rule 19 takes effect, to attempt to shape what the scoping of these requirements will look like and how they may apply to my business. As a secondary item, I think would definitely make sure that we have appropriate processes and procedures in place for governance and general oversight, just given the breadth of items that must be collected and retained and certification requirements of the board of directors.
Dan, really interested in your thoughts on that same question. If you were in-house as a cybersecurity lawyer, how would you be directing your organization in response to these proposed rules?
Yeah, Scott, I echo everything Alaa said. There's one thing I would also highlight. If I was in-house, I would probably talk to my CISO and think about doing audit preparation activities. So this may be going to outside counsel. It may be using my internal audit function. It may be some hybrid of the two, to conduct an internal assessment to get a sense of where are our potential gaps now and what will we need to do to get prepared for this. As you said, it's a little early in the process, but given what a high bar some of these requirements are and how, especially from a papering process, it may not be formally documented, I would rather get ahead of this and start doing an assessment for those areas that aren't maybe covered under existing assessments so that I will feel more confident going into when this does become law.
Or maybe if I can maybe add to that, Dan, because I think that's a really important point. Oftentimes, I think clients are coming to us and I'm working with them on trying to develop privacy and cybersecurity resiliency, right? In other words, expecting that privacy and cybersecurity will be regulated differently tomorrow than it was today, but doing things today that are not just designed to meet today's requirements, but are designed to be more forward-looking so that you are not constantly having to chase the new requirements and you're not constantly trying to play catch up, but instead, even if it's not necessarily required, if you're doing an audit, if you're doing an assessment today, have in mind what this proposed rules are going to be set in place. Because even if the final version may look different, and even if we don't yet know what the exact rules are going to be, if we can use this as a model, that gap that you described could be so much smaller than if we just ignored what these draft regulations are going to look like with the hope that, they will look very different in the end.
I agree with that, Scott, especially, again, regardless of how they change and things end up falling. Not having things formally documented or something for the auditors to look at is going to be very problematic on the back end to try to do when the final rule comes out. So since you're already doing the processes, it makes sense to formally document them.
So with that, Alaa, Dan, thanks so much for joining the podcast. Really appreciate your expertise and your sharing that with our listeners. So that was today's episode. I'm Scott Loughlin. This is the Data Chronicles, and those are your data points.